You know, it's been a bad week for Democrats. Not only is the border wide open, not only does Main Street feel the pressure of 20% inflation, but we saw a pretty tragic debate performance by the commander-in-chief. In fact, Democrats this week are discovering new tunnels on the way to and from the Capitol in which to hide from the media. And so they are now talking about things like Project 2025 and things to distract the American people from what they're really seeing, which is a country that is not doing well under his leadership. It is a total distraction. Let's recap some of the main players we have here today. Alvin Bragg used a novel legal theory to bootstrap a misdemeanor allegation as a felony by alleging that records were falsified to conceal a second crime. Alvin Bragg is a pioneer of sorts, but in all the wrong ways. When you look at what he's done, he's paved the way for rogue district attorneys to campaign on and get elected to prosecute political enemies or political opponents. Then we have Judge Merchan, who's a top Democrat donor. His daughter worked for Kamala Harris and even urged a Trump Organization CFO to be a government witness against President Trump. But when President Trump requested he recuse himself, Judge Merchan said no. He performed an examination of his own conscience, which he found that he can rule fairly and that it would not be in the public interest if he recused himself from the case. A total farce. The left has really stacked the deck on this trial. Judge Wilson, why should Judge Merchan, we talked about this a second, but we're going to wrap up here. Why should Judge Merchan have recused himself from hearing the case against President Trump?
A judge has an obligation to be fair and impartial and to appear fair and impartial. Now, Judge Merchan has the right to rely upon the ethics opinions that he received. He asked a question, he got the answer. But that isn't the end of the analysis. The judge has to also avoid the appearance of impropriety. In hearing the case, after having made political contributions and having a daughter, first-degree relationship to the judge, profiting from attacking the subject of the trial that the judge is presiding over, has the appearance of impropriety.
Judge, have you ever asked specifically a potential witness to be a witness in a case, or have you let the prosecutors and the defense counsel pick their own set of witnesses?
I leave that to the prosecution and the defense. The prosecution is the burden of proof. They decide what witnesses they want to put forward to prove their case, and the defense then has the ability to present whatever witnesses they want. Sometimes witnesses will be irrelevant, cumulative. There'll be other reasons they'll not testify. But in general, the prosecution and defense are the ones that pick the witness.
So if a judge were to do that, in this case Judge Merchan, to ask a former Trump CFO to be a witness in a case, that would be improper. Is that correct?
That's out of the ordinary. It's not always improper for a judge to suggest a witness, but judges don't call witnesses in 99.99% of cases.
Judge, you talked about this earlier, kind of a parade of errors that what was the legal term that you used?
Cumulative. These are cumulative errors.
So would the inability of Judge Merchan to recuse himself, would that be part of a stack that could be used as by a court of appeals to reverse the decision?
I believe so.
What other grounds for appeal do you think are evident from your mind on this particular case?
Well, I go right back to the indictment, and appellate courts like to rule on things that are pretty clear. A clear error is usually the basis that an appellate court will find and not go into a lot of other questionable issues. Courts like to decide things simply in most cases. Here, the indictment was facially insufficient right from the beginning, and it would have been a simple matter for Judge Merchan to dismiss that indictment and to give the prosecutor leave to represent that indictment to get a sufficient one, to give the defendant proper notice of the charges that the defendant was facing. That was not done in this case, and that led directly to the next significant error, which was not notifying the defendant of those additional charges until he was already at trial, and many of them not being notified, many of those charges not being present until the jury instructions themselves.
And then the jury instructions, of course, were wrong too. I mean, it was a 55-page set of jury instructions that were incredibly confusing to an average juror.
Yes, as well as to lawyers for that matter, because I heard that comment more than once that many didn't know what those jury instructions meant.
Thank you, Judge. Appreciate your time.